Good morning, good afternoon, good evening to all the respected dignitaries, distinguished guest speakers, honorable participants, loving audience, and all beautiful people present here from all around the globe. Hi, Ms. Nada Ratkovic, the IIU co-founder Europe, the president of Research Center IIU, IIU board member and country director IIU Croatia. Welcome you all to the first technical symposium on intellectual property rights 2023 on the theme Ideas to Intellectual Property Rights, IPR, the event for all the educators, science, researchers, students around the globe. Today, the inauguration event, the opening ceremony of the 5 days symposium, jointly organized by International Internship University, IIU Research Center, Tupper Institute of Engineering and Technology, Patiela, and Eureka Prize Problems. As I said, on the key ideas to intellectual property rights. Intellectual property rights are the rights given to persons over the creations of their minds. They usually give the creator an exclusive right over the use of his or her creation for a certain period of the time. IPR provides certain exclusive rights to the inventors or creators of the property in order to enable them to reap commercial benefits from their creative efforts or reputation. There are several types of intellectual property protection like patent, copyright, trademark, and etc. But I will not talk today about that. So let me first, before we start, introduce our great organizers. So I'm pleased and honored to present our organizers. International Internship University is a leading virtual education system, global brand confederation, which is the most valuable and trusted worldwide and well reputed in delivering innovative programs. Globally, it is a trusted name for the programs and, for all the young learners of the globe, providing better and virtual education. IIU is metamorphosing the conventional education system by cutting down the additional costs and providing access to more than 1,000 plus courses, internships to their e-learners across the globe with the help of 1,000 plus global educators. In a short span of time, IIU has spread its wings in 195 countries, 6 continents, under the strong leadership of its visionary founder, Mr. Piyush Pandit Sir, a committed and inspiring social activist, passionate educationist from the last 2 decades, providing education to students from various social and cultural backgrounds. The sky is the limit for his dedication and hard work. Let me introduce our second organizer. And first, I want to say that my co-organizer of this awesome, special, unique symposium is well-known Dr. Sovik Ganguly. So let me introduce his institute. He's coming from the Tupper Institute of Engineering and Technology, TIET. And the Tupper Institute is one of the India's oldest and finest educational institutions, which provides a steady source of highly skilled talent to the nation as well as overseas. It's a campus spread across sprawling 250 acres. Tupper Institute and Technology is located in Patiala and has been a pioneer in engineering education, research, and innovation. Our community involves the mind solvers eager to make the world a better place to live in with their innovative techniques and discoveries. It is raised amongst the top-ranked innovation-driven private universities and technical institutes in the country. Constantly, they are involving in teaching methods, providing quality education to the students whom see unique individuals with different interests and aspirations. Our great Sovi Ganguly is also a founder of Eureka Prize Problems. So Eureka Prize Problems is with us today. The objective behind developing the society was to promote research ambience amongst the UG students through organizing competitions, expert talk, seminars, webinars, some technical sessions, and encouraging them to write research articles. The last organizer is IIU Research Center. IIU Research Center is a unique hub and is giving an opportunity to the researchers, authors, educators, students, scholars across the globe and enhances the research opportunities, academic excellence, real-world problem solving, knowledge creation, and dissemination. With high caliber global educators team, we are dedicated to making a considered consideration. And me, Professor Nada Ratkovic, as a president of IIU Research Center, thinks if you have ever thought about how would be the world without education, research, science, innovation, technology, or any development of anything, then the IIU Research Center is the right place for you. But let us today start our program. Let us learn together about the intellectual property rights in 2023 on the day one of this conference. Today we will explore, diverse, and gain international experience, skill, and knowledge. So, let me see. We will start today. I'm so honored today because this is my second symposium with Dr. Sovi Ganguly. And really, last year we have a wonderful technical symposium on the last trend. So today, again, a very interesting, very unique, special topic. And we know today that in this world, from what we can live. So today, I'm really excited. I'm really excited this event can start. Dr. Sovic, I present you or you will present yourself? So let me introduce you. Our great Dr. Sovi Ganguly, who is coming from the Thakur Institute of Engineering Technology, Patiala, India. What to say? If I start reading his CV, I will not finish till tomorrow. I will say that he has completed his PhD in the area of system identification and control at the Thakur Institute. Then he did his MT in mechatronics engineering, many training, research in Kolkata, the Bachelor Tech in Electrical Engineering. He's an assistant professor since June 2009. He has 16 years of experience in academics. Before joining academics, he has served the industry for more than 2 years, and he has organized several workshops and expert lectures for the students. He also worked as a session chair, keynote speaker, conference organizer, reviewer in top IEE, Elsevier, and Springer journals. He has published 18 SCI journal papers, 42 Scopus Index paper, book chapters, conference papers, 17 Australian innovation patents, 4 German patents, 2 South African patents, and who will say all of this? He is promoting senior member in 2022, serving as the president of Eureka Prize Problems Student Society in the Tupper Institute. Let me see, awarded with so many awards from 2022 from CM. His PhD thesis won the Outstanding Dissertation Award. We didn't have doubt, dear Dr. Selvik, about this. So he's really a promising professor of engineering and technical education. with his book, with his classes, with his smart cities, with PhD. So today, at the beginning, before our great Dr. Selvig start his speech, he will have a very interesting topic called Introduction to the Patent Drafting. Please, Dr. Selvig, tell us a few words.
Okay, fine. Once again, I'm heartily thankful to Professor Nada Ratkovic for giving me this opportunity and once again making a technical symposium, and I hope the audience will enjoy the next 4 days too, with some interesting topics related to patent, or more so regarding intellectual property rights. So I'll be just Nada ma'am has already said that I'll be focusing on drafting of a patent, how to draft, what are the different types of patents that we have, and how to make the draft of it. And I'll be talking about also the different types of intellectual property rights as well. And there are honorable speakers as well who will take you through in our next days with some interesting topics like role of IPR in academics and industry.
Professor Dr. Selvig, will you introduce our amazing speakers who will be this
Yeah, sure.
Yes,
Absolutely.
thank you.
It is my pleasure to welcome Dr. Vivek Arya. He is from Gurukul Kangri University in Haridwar, and he is a master of patents, Indian patents. He had been instrumental in drafting patents, and several of his patents are already granted. And I think he'll be talking about role of IPR in academics and industry. So that is also an interesting topic. After that, I think with Professor Arun Rana sir, we'll be getting the flavor of innovations with IoT. And mostly we had been working together in different patent publications as well. On day 4, we'll have Dr. Bipin Chandrapal. He is from NIT Silchar, one of the premier institutes in India. And he will be taking you through some patent ideas or innovations with respect to systems and control theory as well. So once again, an interesting topic. And after that, I think ideas and innovations through IPR will be delivered by Dr. Tapshi Nagpal, from Associate Professor from Lingas University, Faridabad. So this is all we have in store in the next 4 days to come. I think we can start now. I can share my screen and welcome all the participants also to join this particular program for all the 5 days, so that they get benefited at, with the different types of exposure related to intellectual property rights. So although my topic I'll restrict to introduction to patent drafting, but first of all, since it's a technical symposium on intellectual property rights, so I'll be talking about some of the intellectual property rights as well. I'll be taking you that through the journey of what are the different types of patents, and then we'll more or less will elaborate. It's not possible for us to illustrate all the different types of patents, but mostly we will stick to the utility patents or the innovation patents which we had been drafting over the years. And mostly I'll talk about that, what are the different sections of the draft, and what are the tips that relate to development of patent draft, and how do you get adapted to this particular style. There are different people or different speakers who will take you through the different platforms, or mostly they'll talk about IPR and patent and all these things in the next 4 or 5 days. So let me first of all define what do you understand by intellectual property rights, or commonly termed as IPR. So it gives you the legal rights that are granted to either your individuals or even the business houses for their creative and innovative work. So it relates to any kind of invention that is taking place. So basically your purpose of using an IPR will be to provide some legalization that protect your creators' interest in their creations, And of course, that will encourage innovation and creativity at the same time. So this is how we talk about intellectual property rights. So basically, it is a legal right that is being offered or that is being granted to the individuals or to the organizations for their creative and innovative works. Now, these are the different types of intellectual property rights of which we are talking about patent drafting today. I think our speakers ahead will be talking about other different kinds of intellectual property rights. So patents are basically granted to protect any inventions, any process, any product that gives the holder an exclusive right to produce and sell that particular invention for a set period of time. Normally, the durations of these patent are different for different countries as well. In India, we have 20 years. In South Africa, too, we have 20 years for the duration. But in US or other countries, we may have 8 or 10 years accordingly. Apart from that, we can have trademarks as well. That means a trademark is granted to protect some unique names, especially logos or symbols that identify or distinguish products and services. You may have seen several types of logos by Nike or Adidas or Reebok or something of that sort. So basically, these are the trademarks. Apart from that, we can have the copyrights. Copyright is basically it can be some literary work, it can be some musical composition, it can be some copyright for the book or the authorship of the book as well. Apart from that, we can have trade secrets, which is basically a protection of any confidential information about a process, about any particular formula, or any kind of confidential business information that can be called as a trade secret. Industrial designs, of course, we'll be talking about more of utility patents, but in case we are filing a design patent or going for an industrial design, it is basically the protecting the appearance of a particular industrial product, such as based on its shape, size, color, texture, everything. So basically, this is a part related to mechanical sort of design on different say, for example, if you talk about that we are having a solar charging station for electric vehicles. So likewise, we can have these type of designs that has to be made. Apart from that, geographical indicators, these are called GIs in short form. They are being granted to the names and the signs that are used for identifying any product that originate in a particular or a specific geographical location and possess the qualities and or the characteristics of that particular geographical location. Say, for example, we have in Indian origin, we have Indian silk saris likewise. So several teas are very much popular in the area of Darjeeling and something of that sort. So those are coming under the geographical indicators as well. Now, gradually we'll move on into patent and the different types of patents, for which we will first see that how do we define a patent. So patent is basically some legal document that is being granted by any government authority. Say, for example, Indian IP or intellectual property, they issue a certification. So that is basically a legal document that is offered by any government authority or any patent office of a particular country that gives the holder of that particular patent some exclusive rights to make, sell, or use and any invention for a specific period of time. So usually 20 years, but it varies from country to country as well. It depends upon the type of invention that will be short-lived, that may be for a longer duration of time. Of course, patent is being granted by some disclosure of the invention, which should be absolutely new, which should be useful, which has some applications, and which should be non-obvious. Say, for example, I'll quote on one example, algorithms cannot be patented because there are several ways by virtue of which you develop the logic for an algorithm. So an algorithm is never patented. So this is, so what is non-obvious that can be patented? One that is obvious that cannot be patented. So purpose is to encourage any kind of innovation, providing inventors some means by virtue of which they can protect their ideas, they can invest in research and development as well. So patents can be granted over a wide range of innovations. It can be granted, including some machineries, development of machineries, include some processes. I'm hearing some background noise. Please mute yourself. Please mute yourself. It is my request. A patent can usually be granted, including some machines. Extremely sorry for some noise, some background noise at the back. So patents can usually be granted for a number of machines, for some processes, for some compositions of matter, as well as for some designs as well. So coming to the discussion on the different types of patents, mainly they focus on three different types of patents that we will talk about today. One is utility patent, which is based on So talking about the different types of patents, we have utility patents, which is the most common form of patent that you have, and usually having some specific use or a function. So obviously this can be protected based on some useful or some new processes, some machines that are being manufactured, which have some specific applications, some composition of matter as well, and of course any new and useful improvement thereupon. So of course these are the most commonest form of patents, as I'm telling you, and mostly we'll talk about the drafting of an utility patent in my today's discussion. Second is what we call as the design patent or industrial design, which we call it. They are usually granted for new, original and ornamental designs of any article or any manufacturing part. They usually protect the article looks rather than its function. So functionality is not a concern in industrial designs. So obviously the shape, size, color, texture, these things are most equally important. So we have to provide the different views of the diagrams. In our mechanical drawings, we usually give the different types of diagrams for the design patent as well. Apart from that, we can have innovation patents, which are for a short duration of time, usually less expensive than a complete specification. This does not require any examination. They are usually reviewed and they are made available so that that innovation may be short-lived. But of course, it must be new, it must be non-obvious and having some innovative step. So these are the different types of patents that we usually talk about, and we will now go into the sections and the drafting part of the different patent sections. So first of all, most and important is the title of the invention. So usually a patent is not a manuscript that you are submitting. Its title should be very much brief and to the point. Apart from that, it must specify the field of invention. So field of invention is basically the description of the technical field. Say, for example, we are innovating in some domain of electrical engineering or some domain of control systems and control theory, or we are making some innovation in IoT and so on. So these type of fields of innovation must be, the technical field must be mentioned in the field of innovation. Apart from that, we'll have the background of innovation. Basically, it discusses the prior art, what we call, if you have any knowledge about the manuscript or research articles that you are publishing, It is basically the literature survey, we call it. In our technical language of patent drafting, we call it prior art, which includes some description of the problems or the limitations or the disadvantages of the existing solutions, for which some explanation that how this innovation of yours will overcome this problem, this must be specified in the background of the invention. Apart from that, it should contain a brief summary of the invention, describing the key features or the some of the technical specifications. If you want to specify, you can specify it with the summary of the invention. Apart from that, we must provide some brief description of the drawings. What are the different drawings that you have for the patent application? And then we'll have the detailed description of the drawings as well. So including all unique features and including all technical specifications. After that, the most important part of your patent drafting is how do you set the novelty of the work, or how do you set your claims that define the scope of the invention and the legal protection being sought. So these are typically I should say this is the heart of your invention. So be very much careful as we discuss about the claims that are involved in the scope of the invention. So apart from that, we can have an abstract. That is, an abstract must be a brief summary of your invention, and it is to give you a concise overview of the invention to the interested parties. So of course, if anybody is interested in your innovation or invention, so they must contact you by reading your abstract, and then they'll get the details of the figures, invention, field, drawings, everything. Detailed drawings, of course, drawings will illustrate the invention thoroughly. It can be a block diagram, it can be any representation, any mechanical drawing as well, so as to give you clarity to the written description that you have done. So these are the different parts by virtue of which we have to write in drafting a patent. So first of all, we'll start title. We can skip, because a brief title is good enough for you to make an invention or make a clear and concise way of understanding your patent work. We must be very much clear and concise about the field of invention. It is a custom, of course, in Indian scenario, it is a custom to mention the field of engineering. Say, for example, whether it determines or whether it denotes the mechanical engineering domain, or whether it involves the electronics engineering domain, or whether it involves the electrical engineering, or any specific thing that you want to be code. Say, for example, if the work pertains to any invention in IoT and so on, because these are not the conventional branches of engineering. So you must specify the technical field in a clear and concise statement. And of course, we should use the technical terms to be specific about the field of invention. Say, for example, if I want to bring about an innovation in the home automation system, I should talk about some technical specifications, that how do you carry about that particular invention. So be concise, be clear, and at the same time use some technical terms to define the technical aspects, or gives you a deep understanding or an idea basically of the technical aspects of the invention. So these are my tips for writing the field of invention. Then we go into the background of invention. So it should be starting with some general description, just as we normally do in a research article. We start with a background of work or introduction, basically. So giving an overview of the technical field which your invention relates, and describing the prior art, identifying some problems in the prior art, or identifying some limitations of the present state of the artwork. And after that, we can establish for the need of the invention and the demonstration for its potential applications as well. Apart from that, we can also explain our invention and how it addresses the present technical problems or the present limitations that is being identified in the prior art. Of course, it is a good practice to include some references related to different patents. Say, for example, we normally refer the European patents, we normally refer the Indian patents, we normally refer the US patents, or even some of the German patents as well. So those patents are usually popular throughout the world. So if some resources regarding the prior art can be studied and that can be looked in, some limitations can be identified, and then explain your innovation, so that how those innovation or how the invention of yours can bring about some address the technical problems or the limitations identified in the prior art. I think we should explain about the description of the figures. So how to describe your figure, and there should be two types of descriptions. One is a brief description, that what is the figure 1 denoting, or what is figure 2 denoting, what is figure 3 denoting, and so on. And then we have a detailed description. The detailed description will include some specific elements or comments. Say, for example, we usually use some reference numerals. Say, we denote certain parts specified in our figures with some numberings. So those components, what are those components? Say number 1, number 2, number 3, number 4, whatever numbers we are specifying, whatever numerals we are specifying to our elements or components in the invention or the figures, we must always help to relate it in the description of the figures, and explain also the function of each and every element or each and every component. It is also important to explain the function or mention the function of each and every element or component involved in the invention. It may include that how they will perform together or work together to do a particular job, or how they will interact with one another also. And of course, be precise, and in a clear way you can write the description of the figures. So there are two types of descriptions that we are talking about in the patent drafting. One is the short description, or making the examiner identify each and every figure of yours, providing their perspective, their view, their angle as well. And apart from that, we must provide a detailed description of the figure involving all the elements and the components, how they work together to perform a particular function, or how they interact with each other in the invention. So this is what we understand by how do we describe a particular figures. Now, just as I told you, this is the most important part, or the claims of the invention, and how do you justify the claims of the invention. So first of all, before we draft the claims, we must look into certain aspects. That means what kind of an invention is it, and what kind of a problem is it solving. So this is most important, and of course determine the scope of the invention. So your claim should not be a narrow claims. It should be broad enough to cover all possible embodiments of the invention. So it should avoid your prior art or something of that sort. It should not be narrow enough as per your prior art, and it should be a broad topic that will cover all possibilities of the invention. Okay, and apart from that, your claims should be clear, concise, and leaving absolutely no error for ambiguity. So if your claims are ambiguous, definitely your examiner won't be able to understand, or won't be able to give credit to your claims as well. So typically, how are claims written? They are written in a particular standard format that includes some preamble, that includes some transitional phrase, and then a body. So how is a preamble being written? They are usually identified the type of claim and the specific field of technology in which your innovation or invention relates to. Transitional phrase will connect the preamble to the body of the claim. So this connectivity should not be destroyed. If there is no connectivity between your transitional phase to the body of the claim, then people will lose track of it. So body specifies the elements involved in this, or rather the specific elements involved in the invention. So there are three aspects that you must look into. One is, how do you identify the type of the claim, and what is a specific field of technology in which your invention is associated with. And then you talk about the transitional phase that connects, that makes a connection between the introduction of the technology with the body of the claim, and the body of the claim will specify the required elements of the invention. So this is how you can have a look at now any patent draft, and you can easily go through any patent draft available in Google Patents, and you can go through that what I'm telling, whether you can connect it with that or not. So because it is a standard format for writing the claims, be it an Indian patent, be it an European patent, be it an American patent as well. US patent also follow the same thing, that there should be some introductory part, there should be some transitional phrase, and there should be some body of the claim. So this is how we draft the claims of the patent. Now, finally, we reach at the abstract of the patent. So, of course, abstract, as I follow the sequence, abstract is written at the end. Once you are done with the job, once you have drafted the field of invention, once you are given the background, made the appropriate prior art search, after that, you briefly describe your figures, you give a larger description or elaborate description of your figures with some numerical numbers. You specify the different parts of your invention, and after that, supported by, of course, your drawings, then you reach at the claims or the novelty of your patent, and that should contain three aspects, mainly the introductory part, the transitional phase, and the body of the claim. So after you are complete with all these things, you are absolutely thorough with the drafting of the patent. Now you can give a concise overview of the abstract. Usually, looking at any research article or looking at any manuscript submission, you can check out that abstract is written in 3 or 4 sentences. Basically, it gives you the, first of all, the objective of your work, that how you have carried out that particular work, and finally, what are the outcomes that you have. So your abstract in a patent must be brief and to the point. And of course, some typical way of denoting abstract is it should lie between 150 to 250 words. It is also the same type of format that we usually follow for writing any abstract of a research article as well. Include the field of invention. The field of invention must be specified in your abstract, and a brief description of the technical area that your invention pertains to must also be specified. Apart from that, you must give a description of your invention as well. So a brief description of your invention must be provided, so to get hold of your key features, your components, and what are the relative merits of your invention as well. Apart from that, it should be clear and written in a concise language that is accessible by a broader audience. Broader audience means it can be easily understood by even a layman who is reading your article and who is getting a feel of your invention as well. Apart from that, it must highlight the technical problem. Whatever technical problem that you have addressed or that your innovation is solving, that needs to be explained and highlighted as well. And also the information regarding the limitations of the existing technology, and preferably if you can give a market demand for a new solution. So that is also equally important. Sometimes your product may be cost effective as well, although same type of solutions are available in the market. So that way also we can call it that your innovation is also novel. And also it must provide some technical solution. So what is a technical problem that has been addressed? What is a need for that? And then you come to the discussion that how that invention, how your invention is able to solve the particular technical problem that has been addressed. Apart from that, it also must include some information regarding the specific components or the features of the invention that makes it unique and that makes or gives it an innovative solution. So these are the things that you must go through while drafting the abstract of your patent. Last but not the least, we will come across how do you prepare the drawings for your patent. So first of all, the drawings can be it may include some size, some format, some labeling, some quality of drawings. Of course, I think colored drawings are usually preferable for industrial designs as well. You can use some professional softwares like AutoCAD and other things to do the mechanical drawings. You can use the Microsoft Visio, eDraw, other softwares as well to make some construction of block diagram or flow chart or something of that sort, by virtue of which you want to relate your invention. Apart from that, it should be absolutely clear, simple, and it is easy to understand. Even a layman can easily understand or relate to your drawings and relate the invention to your drawings as well. This is what your examiner demands for. So at the same time, your drawing should contain some labeling. That's why we were telling you that you should prefer to give some numbers to the different parts, to the different components of your invention. So this will clarify your invention and makes it also easier for the examiner to understand. And if you can include some multiple views, normally we include multiple views for industrial designs, but if you can include multiple views for the invention, it is preferable to show different perspectives and different detailing as well. So this gives your examiner a complete understanding of your invention. So these type of things must be remembered while you are typically going for the drawings for the patent. So mostly we talk about some use of a professional software like AutoCAD or something of that sort to elaborate or illustrate the drawings, and it must be of high quality. Specifically, it must be clear, simple, and easy to understand as well. So these are some of the tricks that you must follow. And preferably you can, if you can create some front view, some rear view, cross-sectional view to give you a better idea about your invention and its details as well. So these are some of the tips that you may remember for drafting a patent. So let me summarize the aspects that we have talked about today on the different intellectual property rights. We talked about specifically about the different types of patents. There are different aspects that you need to write, so that we specifically went into the detail of drafting of a patent with specific emphasis on the utility patents. And we talked about that how will you write your claims, how will you write your field of invention, how do you write the prior art and the problems in the present invention, so that or the existing technology, and then you can overcome how your invention or innovation can overcome those limitations can also be. Diagrams or drawings, you can take the help from some mechanical engineers or something of that sort, if you can brilliantly express your ideas through some drawings. And of course, drawings must be very clear enough for the examiners to understand your work as well. So this is how we go about it regarding patents and regarding the drafting of utility patents. So that's all I need to share today. Thank you very much, IIU. And of course, we have some good amount of speakers ahead for carrying through the entire journey of technical symposium on intellectual property rights as well. Over to you, Nada ma'am, please.
Thank you. Thank you. Great, Dr. Solvik. Thank you for your great speech, for a great presentation. I see our audience is very satisfied today with the first day of the conference. I want to thank you. Thank you for helping this, for being with me in this organization. Also, I want to express my gratitude to our founder, Sir Piyush Pandit, giving us opportunities to share knowledge all around the globe. You were today amazing. My hearty gratitude to you. So once again, thank you, lovely audience, for being a part of this first day of the conference. See you today, tomorrow. At day 2, we have a new esteemed speaker and expert. Till tomorrow, keep reflecting, learning, collaborating, enjoying, and being nice to yourself. Thank you. Thank you so much, and see you all tomorrow. Tomorrow. Bye.